This Honorable Court of Appeals is now in session.
Good morning, counsel. Before we call the case, just if we should have any technology-related problems, everybody just, can you not hear me?
I can hear you, Your Honor.
You can hear me, Mr.
I can't hear.
You can't hear. Mr. Evans, can you hear me now? Okay, everybody else hear me okay?
Yes, your audio is working.
Okay, Mr. Evans, can you hear me?
I can't hear anything.
I am messaging him right now to try turning his computer speakers on.
Hold on just a second. I think I heard something just then.
Mr. Evans, can you hear us now?
Yeah, I hear you now. Thank you. I don't know what happened. Let me
Okay.
just a little bit. I had the volume so far up.
As I was getting ready to say, very appropriate that if we should have any technology-related problems, everybody just take a deep breath and we'll take a pause and work through them and get back up and going. Don't anticipate any, but sometimes they arise. Deputy Clerk, call the case, please.
Timothy J. Pagliara versus Marlene Moses et al.
We'll hear from the appellant.
Thank you, Your Honor. My name is Paul Krogh, and I represent Mr. Pagliara, the plaintiff and appellant. I would like to reserve 3 minutes for rebuttal, please.
That'll be fine.
May it please the court. This case concerns the application of or the process for recovering fees under Tennessee Code Annotated Section 2012-119C. Its resolution, however, we submit turns on the intersection of two general principles. The first is that rights must be exercised in conformity with applicable procedural rules. The second is that statutes creating rights should be read in harmony, in conformity with those applicable procedural rules. And we have an important guide that I'll talk about and how to do that in this case from the Supreme Court in the Estate of Hare case. We know that you can lose or impair your rights if you don't follow the rules for exercising them. There's an excellent quote on that topic from the United States Supreme Court, the Insurance Corporation of Ireland case from 1982. And in that case, the court said, the expression of legal rights is often subject to certain procedural rules. The failure to follow those rules may well result in a curtailment of the rights. And this court, in more recently in 2001, in the Wright versus Quillen case, applied that principle to a divorce action and a statute that created a right to reopen divorce proceedings. And the plaintiff and the movement in that case had sought to reopen his divorce proceedings many years after the fact, and he claimed fraud. And he cited not just Rule 60, he cited a statute that allowed courts to reopen divorce proceedings and said, well, there's no time limit on the statute, so I can do it whenever. And this court said, while we agree that the statute does not contain such language, that being time-limiting language, we also note the statute contains no language suggesting that any determination requiring a new trial is exempted from the normal rules contained in the Tennessee Rules of Civil Procedure. This court feels that it is not the intent of the legislature for the statute to usurp these rules. And that, of course, is the generally applicable rule. When the legislature wants to change the generally applicable rules, it says so. And there are doctrines about how to interpret statutes that hold that the court doesn't revoke or rescind or overrule otherwise applicable rules by mere implication. It has to do so explicitly or in a way that's very clear. And here we have a statute that allows a defendant, when it files a motion to dismiss, to recover this award of attorney's fees. But the statute doesn't say anything setting aside or impairing or changing the ordinary operation of our rules governing finality or reopening judgments. Right? It doesn't say that, it doesn't change the rule that claims have to be asserted before the entry of a final judgment, or that it doesn't change this court's longstanding doctrine that attorney's fees impair finality, that they're part of a final judgment and have to be awarded, if at all, before the entry of a final judgment and can be lost if not. Right? This court applied that principle in the Seaton versus Wise Properties case in 2014, where a party had a contractual right to attorney's fees as the defendant. Defendant didn't ask for those fees. Final judgment was entered not awarding them. And then when the plaintiff appealed, there was no issue of the fees raised on appeal. And after remand, the defendant said, "Oh, I want my attorney's fees now." And this court said, well, it's too late. Right? There was a final judgment. You didn't get the fees. And the final judgment cuts off that right, even though you might have had it in the first place. And that's precisely what we have here. We have a defendant who moved to dismiss, who had a right under the statute to recover attorney's fees, but who didn't ask for them. The trial court didn't award them, and nobody raised that issue on appeal. And the court heard the plaintiff's appeal, remanded not even for further proceedings, but merely for collection of costs below. And then after remand, the defendants came back and said, now we want those statutory fees. Even though there had been a final judgment was affirmed, and the remand instructions didn't call for reopening of the judgment in any way. And what the trial court said in this case is essentially what the trial court had said in the Wright case. Well, it says there's no limitation in this statute about when I can do this. And in fact, it says I have to do it after the appeals are exhausted. So I think I can do it now, even though there's not any preservation of the claim prior to the entry of the final judgment. And respectfully, that turns the system on its head, right? We have, in that case, a situation in which there's no limit on when the fees can be sought, and there's no certainty about what's a final judgment and what isn't. And in one sense, the statute creates a problem for how to take appeals, how to hear appeals, and how to deal with this issue of this statutory right. And the solution is right there in the system of civil procedure. And the Supreme Court points to it in footnote 10 of the estate of Hare versus Webster case from 2019. And it's, as a side note, the court has discussed this statute and its sort of interplay with the final judgment rule in two relatively recent cases, right? The Donovan case and the Irvin case, both of which are mentioned in the parties' briefs. And if you look at the briefing in those cases, and you look at the opinions, nobody mentioned the estate of Hare. When I read the Irvin case, and because I represented one of the appellees in the estate of Irvin case, and I read that opinion, and I thought, well, why don't they talk about the estate of Hare? I went and looked at my brief, and I said, well, Paul, they didn't talk about it because you didn't cite it. And that's, we have an adversarial system of justice. The court relies upon the parties to frame the issues, and if the parties don't point the court in the right direction, you can't very well blame the court if they don't talk about the authorities that nobody mentioned to them. But because of that, because nobody mentioned the state of Hare in those two cases, it doesn't come up in the Donovan case and the Irvin case. And in footnote 10, though, in the state of Hare, the Supreme Court says, in short, the way to solve the problem posed by this statute is to use a 54.02 certification, right? The attorney's fee right by the defendant, that's essentially a standalone claim. And so when a court grants a motion to dismiss under 12.026, what it can and really should do, and what you see a lot of judges now doing, is certify the dismissal, certify the disposition of all of the plaintiff's claims as final under 54.02, and then reserve all those issues about the award of attorney's fees to the defendant, and those can be disposed of after the merits appeal in the manner directed by 119C. And that's clean, it's efficient, he doesn't multiply the proceedings, and it comports with the statute. It's a way to do precisely what the statute tells us to do in a way that is consistent with the existing procedural rules, which is exactly what Wright versus Quillen says we ought to be looking for. That ought to be the guide for how to interpret statutes that create substantive and procedural rights. They should be harmonized with the existing rules. And so that's what could have happened in this case if the defendants had sought their fees in a timely manner. There could have been 54.02 certification, we could have had that merits appeal, and then we could have a second proceeding over the attorney's fees. And frankly, we probably wouldn't even be here if that's what had happened, because the amount in controversy wouldn't make it worth it. I wouldn't be here arguing that Mr. Evans' fees were unreasonable as in due to rates or time expended on this case. If that issue had been preserved in the initial, prior to the initial entry of the final judgment. But because they weren't, the judgment cuts them off. And we think that's consistent with the system of procedure. We think it's consistent with the generally applicable procedural rules, and it's consistent with the text of the statute that doesn't change either of those other things. So for those reasons, we submit that the judgment below should be reversed and the final judgment reinstated without any award of attorney's fees. Unless the court has any questions, I will save the rest of my time. I will simply await rebuttal.
All right, I hear none. So thank you. You have your time for rebuttal.
Thank you.
We'll hear from the appellee now.
Your Honor, thank you, Your Honor. I want to be sure, can you hear me okay?
Yes, sir.
Good. I think the trial court hit on the nail of the head and couldn't have said it better. The plain language controls. And to quote the trial court, the plain language of TCA 20-12-119A-C3 controls. Nothing in the plain language of the statute suggests that in order for an award to costs to occur, attorney's fees must have been requested prior to entry of the final judgment and the ensuing appeal. Nothing in the plain language of the statute suggests that the presiding judge's discretion to award costs is somehow limited by language of the appellate court uses in its mandate. We submit that the trial court was exactly right in what it said. The statute controls, and this statute is a statute of Tennessee, and the Tennessee statute says you shall stay any collection of those fees, which means you can't do anything until you collect the fees. But by corollary, if you will, you aren't required to file a motion to collect the fees before the judgment becomes final. And there's good reason for that, for the statute and the plain language, because in the Irwin versus Greenwise Homes, which was decided February 24 this year at footnote 6, the court says the utility of section 20-12-119C3 is apparent, requiring parties and trial courts to litigate the reasonable and necessary amount of fees prior to the appeal of a case dismissed under Rule 1202 would do nothing to promote finality of judgment or judicial economy. And that's exactly what we have here. There's no point in having all the trial courts or even the Court of Appeals delve into a motion or application for these fees when that, if it's the circuit court's reversed or the Court of Appeals reversed, then you're wasting time. Because if either the circuit court or the Court of Appeals or the Supreme Court says, no, we're going to reinstate the motion to dismiss is denied, this matter proceeds, well, then you've wasted all the time about arguing about the fees. So in short, as the Greenwise case made clear, this is consistent with judicial economy, and we say that's consistent with the plain language of the statute, just as the trial court says.
What about when you have a situation, what about a request for fees, but the judge not ruling on the request or not granting the fees until the process is completed?
There is, as Your Honor made that point, I think you're driving at in the Donovan versus Hastings case, where there was a quote request for fees before the motion to dismiss was granted. I think it was made 23 days before the motion to dismiss was granted. I don't think that is relevant, because if you look at the rest of Donovan versus Hastings, the motion for fees, as distinguished from a request in some kind of a pleading, is not a motion, because the Donovan versus Hastings case, you will find, was not filed. That motion for fees in Donovan versus Hastings was not filed until July 5th of 1990, which was 12 days after the order became final in Donovan versus Hastings. So we say that's exactly the case we have here, because our motion for fees was made 12 days after the permission to apply permission for cert was denied. Same thing, the same 12 days. Now, the mandate was issued 3 days before our motion was filed and 4 days before our mandate was filed. So I think that reinforces the situation. But I hope I've answered the question. The request for fees is not what's controlling. It's got to be actually a motion for fees. Otherwise, this court in Donovan versus Hastings wouldn't have been having its discussion on the basis of that motion in July 5th of 2019. So for all of those reasons, we think it's a very simple case. And
let me ask you a question. The statute, and I think we said this in Donovan, that mandates that an award of attorney fees and costs be stayed until a final decision, not subject to appeal is rendered, correct?
That's correct.
If attorney fees haven't been asked for, what's being stayed?
In the event somebody goes further.
I know, but normally if there's a stay on something, something has been asked for, hasn't it?
Normally that's the case if the court please, but the plain language, like the circuit court said, the plain language still does not require you to file the motion for costs before the judgment becomes final. That's exactly the point the trial court made. Now, if you want to go ahead and file a motion for fees before it becomes final, great, do it, but your motion stayed. And that's what I mean. You may file it, but you're not going to do anything with it. So
it's stayed even though there's no motion filed. The motion is stayed even though no motion is filed.
No, I don't mean that. The court is, if you have filed a motion,
yeah,
the motion is stayed before further consideration. But the statute doesn't say you have to have the motion
I
filed and
understand.
stay it. That would be superfluous.
I understand that. I'm just trying to kind of square with the idea that the statute says the award is stayed. Okay, that's fine. You've answered it.
Okay, thank you, Your Honor. So if any further questions, I'd be glad to answer them, but I just refer the court to the plain language of the statute. As the trial court said, the holding of Donovan versus Hastings, and then the footnote from the Greenwise case, which says, it's just contrary to judicial economy to proceeding with a motion for fees. And so what we're saying is, if you want to file a motion for fees beforehand, you can do it, but you're not going to get anywhere with it. You're stayed. You can't decide anything. That motion is stayed. So,
but the point is then, must there be a motion filed
no, Your Honor, no.
to stay?
Can do it, but if you do it, it's stayed. But so that's the rule. I mean, that would be to say you had to file the motion and then stay it. To me, respectfully, it doesn't make any sense. Now, why would you have a requirement that the court has to file the motion, but say immediately, don't do anything about it until we go through the Court of Appeals and the Supreme Court? Even though you've got to file this motion before the stay, you would have to file the motion and before you could do anything with it, and then wait for a year to finally decide. I mean, it's just no point. That's an exercise of futility to require that the motion for fees be stayed before we know what the outcomes are. I hope I've made it clear to the court.
Thank you. Mhm.
Okay. Anything else, counsel?
That's it. That's it, Your Honor. Thank you.
Thank you. We'll hear from the appellant in rebuttal.
Thank you, Your Honor. Only a few points. Mr. Evans noted that the trial court emphasized that nothing in the statute requires that a request be made before the entry of judgment, or that the award of court's discretion be limited by the mandate. And the response to that, Your Honor, is simply that why would you expect the statute to say those things? Those are basic prerequisites, basic assumptions of our system of civil procedure. No one expects a statute to say every time you have a new rule, now go out and apply all these other rules too. That would be exhausting. There would be no end to the code if you had to restate all the rules of civil procedure in each statute. All that does is take us back to Wright versus Quillen, that when you have a process, you have a right, you apply it in conformity with and in light of the other procedural rules. And both the requirement that claims be brought before judgment and the trial courts abide by the mandate of the appellate court, those are both existing procedural rules that underlie the entire system. We don't look for them in each statute. We only disregard them if the statute tells us to explicitly. Irvin footnote 6 in the Irvin court's hypothesis that this would be extremely wasteful to have to litigate all the fee issues before the first appeal. As I discussed with reference to Rule 54.02, I don't think that's the case. I think the Irvin court, because nobody in that case pointed to a state of care or raised the issue about segregating the fees out in a clear way, that's not necessary, right? You could have you could save all of those fee issues, as Judge McCarty, as you noted, you could save all of that for after the first appeal. That's not actually a problem. This idea about the stay directive rendering initial requests futile, that's not the case at all. It's not futile to raise the claim before the entry of final judgment in the first case, because it lets you know what's in the case. It lets you frame the issues in the case so you know what's at stake and what's being dealt with. The same way that you do with any claim, right? There's a system of rules for asserting claims within a case, and you have to follow those rules. Otherwise, it's just a free fall. We can always bring in after the fact anything we want. We don't have a system, we have a circus. And the statute doesn't create a circus. It's meant to be applied with a system of rules. Thank you.
Thanks to counsel for both sides. We appreciate your briefs and your oral arguments on this. If you would please adjourn court till our next regularly scheduled docket.
This Honorable Court of Appeals stands adjourned.
Thank you.
John.